Yes. Hello, my beautiful friends. What an amazing day it is. Welcome back. I hope that your week is unfolding beautifully. Very glad that you're with us today. We have a great stream planned ahead. Quick preview. Then we are going to dive right into the documents. You can see we've got an appeal, a petition to the Supreme Court of the United States. And this one involves E. Jean Carroll. You remember her. The lady who named her cat after female genitalia and other things, painted her trees blue. And really, her biggest concern was manufacturing, in our opinion, charges against the president based on the evidence that was presented. There's a lot of open questions about a lot of it. And now the Supreme Court is going to hear the president's argument. So we'll go through it, see what the latest is. This case has been percolating for a while, and we're happy to have some answers from SCOTUS very soon. Then we're going to turn our attention over to the James Comey case because we got some transcripts here. They had a telephonic hearing yesterday and very short proceeding. They're still duking it out over these grand jury materials. And so we'll talk about that because a lot of this stuff happening under seal. And the last time we were talking about the James Comey investigation, we learned that there were other search warrants that were issued a long time ago that were apparently brought up. And some of the emails from Comey back during the time of the allegations were sent to his lawyer at the time, who is his lawyer now. So a lot of questions about what's going on, and we'll go through the transcripts. We got them from one of the best court reporters of all time, Diane Salters. We love you, Diane. Thank you for the transcripts. And we'll see what the latest is. We've got some other orders from the judge. A lot of stuff is now hitting the docket under seal. We've got affidavits from the FBI, special agents, Francis Nero. His name is Francis Nero. That's pretty cool. It's like from the Matrix or something. And we got that. So we'll see what the latest is with Comey and understand what's going on with the grand jury records and the other search warrants before we turn our attention over to this whistleblower memo that came from somebody we're very familiar with. You saw her on the thumbnail, Christina Bobb, over to the DOJ. Now, this just got published over from Judicial Watch, and apparently she's now a lawyer over at Judicial Watch. And so we'll see what they have shared with us. It's a memo to the DOJ, and it is juicy because, as you can see, she is saying there appears to be organized bribery in the state of Arizona. You're kidding. No, say it isn't so. So we'll go through that. It's going to be a nice memo. We're excited to unpack all of that. And we got some clips from Christina Bobb and the Arizona Attorney General, Chris Mays, who is the person prosecuting Christina Bobb for election fraud, whatever. Her case is falling apart and failed. So it's going to be an amazing stream, my friends. Sorry for the technical difficulties that we had yesterday. Hopefully we blew the tubes out and we're coming across loud and clear today. We had an awesome members only stream. This morning we talked about, the BBC, Trump's threat to sue them for $1 billion. And then people resign and they're like, we stand by our journalist over at the BBC. How some tea and crumpets. You say, what? You're rigging the election. They released their video a week before the election in 2020, and now they're all freaked out about it. So they don't want to lose $1 billion like the other American companies have lost tens of millions of dollars. And so we got some resignations there that we talked about this morning. All fun and a good time. Thank you to our members who support us. We're very grateful for our members, and we'll have a members only after party after today, after the show. And so if you are a new member or thinking about becoming a member, stick around because we'd love to see you. All right. So we've got a lot of good stuff to get to, but before we do, man, shout out to our veterans. Can we just say shout out to our veterans? And the White House did the same. They said, America's veterans safeguard our nation's birthright of freedom. Because of their strength and courage, America stands safe, strong, and free, forever the bravest and mightiest nation on earth. Happy Veterans Day to all those who served. Over from the White House. Nice little montage. You just saw it here. Shout out to our veterans. We salute you. All right. And so now, my friends, let's get into it because we're going to the Supreme Court. President Trump going to the Supreme Court in the case of E. Jean Carroll. We've been waiting for this one. This was the lady who said that Trump Bergdorfed her in a dressing room in Bergdorf, that old department store, a long time ago. She couldn't really remember when or what happened, or there's no corroborating evidence at all. And the witnesses that she allegedly called after the event all were like, this lady's whacked. She's also had a weird fixation with Law and Order. You remember her. She's on the thumbnail, and the AP is reporting that now she is getting appealed. And this is the photograph of her over at the Caring Foundation. She's like a superstar there on the left. And the lawsuit, as we know, and as they're going to mention in the Supreme Court petition, was funded by the left. Guys like Reid Hoffman were dumping hundreds of thousands of dollars into her operation. They basically revised the law in New York to allow her to file a lawsuit. Trump responded to a lot of this while he was the president, saying this lady's whacked. And then she sued him for defamation. And the numbers were massive. Now, in this appeal to the Supreme Court, the petition, it's about $5 million. But remember, there was another Carol 2. It was Carol 1 and Carol 2. And Carol 2 was defamation and punitive damages to the tune of like $93 million. Remember that? Another just attack vector on President Trump. You had Tish trying to bankrupt him with his fake fraud case and his building loans that nobody complained about. Alvin Bragg suing him for the business records fraud that was totally fraudulent, is now being appealed. Fani Willis had her case dumped out. Jack Smith's cases both dismissed. This was another attack vector, not to mention they tried to throw him off the ballot, and the Supreme Court had to step in and say, are you people dumb? So round and around we go, and we're still trying to get vindication on this one because this was insane. And the judge came out, and remember the jury also, the verdict on this case, when it actually came to the, penetration issue, they said that there was no, you know what I'm saying? There wasn't any of that went down. They said, no, we, the jury, find no. Then on the yes, they were talking about, like DJ, era, kind of using your fingers and era spinning records and whatever. And that's what they were talking about. And that's ultimately what he got found liable for, civil liable. But then everybody said that the president had been convicted of assaulting a woman with his fingers. All right, around and around we go. Okay, we know the story, all ridiculous. Let's get to the appeal. All right, this is the woman we're talking about. She was also painting her rocks, painting her trees blue. She named her cat Vagina, in case you forgot about that. And here is more. On petition for writ of certiorari to the Supreme Court, coming out from President Trump and the DOJ, we've got several questions here that we're going to ask the Supreme Court to answer. And of course, we'll get into them in detail. So we fast forward through the table of contents and the authorities and all the various things that we don't care about. Talk about the decisions below for a little bit of procedural history. So remember, we had the trial in New York. The judge's name, I believe, was Kaplan. No relation to the prosecuting attorney, or in this case, the plaintiff, Roberta Kaplan, who was representing crazy E. Jean Carroll. Second Circuit, they came down and they said, Trump, you lose. They denied Trump's request. And so now we're knocking on your door, SCOTUS. Here's the background. In case you forgot, they write, all right, Supreme Court, remember this. In 2019, E. Jean Carroll, she first raised facially implausible, politically motivated allegations against President Trump about conduct that purportedly occurred decades earlier. President Trump has clearly and consistently denied that this supposed incident ever occurred. No physical or DNA evidence corroborates her story. There were no eyewitnesses, no video evidence, no police report or investigation at all. Carroll admittedly never reported the supposed incident to the police or sought video footage from the department store, Bergdorf's, where it allegedly happened, despite claiming that footage did exist. Weird. No reference to the supposed incident exists in decades of subsequent communications with her supposedly bolstering witnesses that we'll talk about. Instead, Carroll waited more than 20 years to falsely accuse Donald Trump, who she politically opposes, by the way, until after he became the 45th president, when she could maximize political injury to him and profit for herself. And notably, her allegations are a story that precisely matches the plot line from an episode of one of her admittedly favorite TV shows, Law and Order. Dun dun. To have any chance of persuading a jury, Judge Menashe explained in his dissent at the Court of Appeals, Carroll's implausible, unsubstantiated assertions had to be and repeatedly were propped up by a series of indefensible evidentiary rulings. Improperly admitting highly inflammatory propensity evidence, which is evidence that tends to show that you're going to do it again. Okay, it's like, okay, you're on your trial. Did you rob this bank? Well, we got to prove that in this instance. But what if they said, well, we know that you robbed a bank like 10 years ago and 15 years before that. So just because you've done those two, we're going to admit those and we're going to say, well, ladies and gentlemen, because he robbed those two other banks, he probably robbed this one. So convict him. Nope, can't do that. So they did that in the lower level court. They just, oh, come on in. They access Hollywood, all these other things. So because he said you grab him by the P, then they said, well, you bring that in here, because if he said it over there, then it's likely that he did it right here. Well, do you have any facts in this case? No. So they just used that as propensity evidence. They said they just allowed all of it in. These striking departures from the federal rules of evidence erroneously allowed testimony about multiple decades-old, unverified, and unrelated allegations to be presented to the jury that had no bearing on the facts of this case. As a result, quote, the judge said, no one can have any confidence that the jury would have returned the same verdict if the normal rules of evidence had been applied. Yeah, we know why they weren't. Now, under the laws, the same rules should apply equally to all defendants. Okay, nobody's above the law. Sure, yeah, they kept saying that constantly. Of course, the Democrats are above the law. Many people responsible for all sorts of crimes are running around free right now without a care in the world, apparently. But nobody's below the law either. And Trump was repeatedly denied basic safeguards of jurisprudence and due process. That did not happen here, clearly. The Second Circuit's decision, which is now embracing a series of anomalous holdings to affirm the judgment of the lower court, created and deepened multiple significant circuit conflicts over the interpretation of important rules of evidence. First, the Second Circuit's decision to truncate Rule 403 when admitting propensity evidence conflicts with decisions by the First, Seventh, and 10th Circuit, which have correctly held that district courts should apply the same Rule 403 analysis that they would apply to any other evidence. Okay, so how do you treat evidence under this Rule 403? And back during the trial, we talked a lot about this because Rule 403, it's kind of this balancing test. On the one side of the scale, you ask, what is this evidence? Is it probative? Is it going to help us answer a question in this trial? That's an important one. Some matter. We really need to get to the bottom of, is it going to help us with that? Yes or no? Put that on one side of the scale. On the other side, how harmful is this evidence? Is it prejudicial? Is this going to unfairly confuse the jury or waste time? There's all sorts of different, ways that it can be unduly prejudicial, and you just balance them out. And if you need something more than it hurts the safety, the kind of the sanctity, integrity of the case, you let it in. And if it's opposite, if it's going to be very prejudicial, but it would answer some questions that are not that important, then you keep that evidence out. Lots going to be on that rule. Second, the Second Circuit's erroneous. And so here they're asking, well, what about propensity evidence, just like the bank robber example? Do we apply that under a more exacting standard or a looser standard under 403? They'll explain. Second, the Second Circuit's erroneous conduct-specific approach conflicts with the plain text of other rules, and it ignores a categorical approach. And in other words, the Second Circuit is just garbage. All right, Supreme Court, so you need to do something about this. They write, in 2012, the TV show Law and Order, SVU, dun dun, ran an episode in which a business mogul fantasizes about R-ing a victim in a Bergdorf Goodman dressing room while she was trying on lingerie. It's Law and Order SVU season 13, episode 11, with that one actor, that everybody loves. Aired on January 11, 2012. Now, this plot line is virtually identical to the false allegations that E. Jean launched against President Trump more than 2 decades after the supposed incident, with not even Carroll being able to provide an exact date. It kept changing. We don't know when it was it like 25 years ago, 24 years ago? She's like, well, ballpark. You're like, Judge, we need a little specificity in this case. It's close. It rings true. It has all the hallmarks of an attack in Bergdorf's. Carol admitted, she said, I'm a big fan of Law and Order, but she conveniently professed not to watch SVU. Yeah, right. We know you did. Everybody did. It's the most popular one. But even she called the identity between her allegations and a plot line an amazing coincidence. Eugene, isn't it strange that you're saying something happened and it's literally exactly what happened in Law and Order? Well, that's astonishing, she says. Wow. Carol also acknowledged that other parts of her story are inconceivable. She agreed that it was inconceivable and cannot be imagined that there was supposedly not a single other person on the 6th floor of Bergdorf's, a busy New York department store at the time that she allegedly got Bergdorfed. She also admitted that it was an amazing happenstance. I know everything's so amazing, weird, that the dressing room door was supposedly unlocked and open instead of closed and locked per their policies. Bergdorf's is a big, nice store, you know, or was, I suppose. And Trump, according to her, just waltzed on in there. And he didn't even take a number of items that he was supposed to, apparently. The lack of objective and physical or corroborating evidence also undermines her story. Even though Carol falsely and publicly boasted that she possessed Trump's DNA, remember that crap? She moved at trial to exclude testimony about DNA evidence. They said, I got the DNA of the president. Oh, great. Good. Prove that. Let us see it so that you can prove your claim, right? And she declined to offer to test the DNA evidence. If you have the evidence, maybe you should use it. She didn't. Clearly suggesting that she expected the DNA evidence to contradict her story and support President Trump's position. Now, Carol claimed that she believed that Bergdorf Goodman could have video evidence of the alleged incident, but she never took any steps to obtain or preserve that supposed evidence, of course. Now, Carol never filed a police report, never sought an investigation, never made any public accusation against Trump until more than 20 years after the incident when he became president. Now, tellingly, through years of discovery and media interviews, strangely, Carol could not even recall the exact actual date and time of the incident, further preventing Trump from defending it, from testing her story through objective evidence to say, oh, I can look at my schedule and I was not even in New York at the time. Can you give me a date so I can validate it? No, it happened in this 2-year window. And it's probably going to happen whenever Trump was in town, whatever, right? Then once discovery was closed, she took the stand at trial and suddenly and inconceivably recalled for the first time and with dazzling specificity the incident, we remember, occurred on a Thursday evening in the spring of 1996. She's like, perfect. A date and time that conveniently matched information that Carol had obtained in discovery. So in other words, she requests some information from Trump, like maybe they get his itinerary. And they're like, oh yeah, he's in town. And she's like, oh, perfect. He admitted he was in town on this date. She comes out at trial. We were all shocked. We were covering this trial at length, both of them. And the second time, like, what? She suddenly remembered the date? This is ridiculous. For years before that, no date. Carol openly admits she's also a professional fabulist, aka, we'll call her a liar. She stated under oath that her public writings are not truthful, but they reflect a fictional public persona called Ask E. Jean, her alternative personality, who is a figment of her imagination and does not reflect Carol's own thoughts and attitudes, like a crazy person. Now, Carol never explained why the allegations in her published book about President Trump came from the supposedly truthful private E. Jean Carroll, as opposed to the fictional untruthful persona Ask E. Jean, who supposedly authored all her other public writings. Interesting. So she changed her identity. In fact, Carol's original versions of her book did not mention President Trump at all. No, Trump was only added well after the project began. And even then, he was not permanently fixed in the book until the very end. They had to shove him in there, 1, to sell books, and 2, so that they could attack him to sue him. Now, Carol's story also suffers from a tidal wave of bias evidence. E. Jean admitted that she detests President Trump. She said it, stating that she watched in horror as he won in 2016. She described Trump as evil and vile. Her idea to sue Trump was crystallized during a conversation with the other maniac, the Oompa Loompa, called George Conway, the obsessed anti-Trump activist who we saw very recently with the scarf on out there at the No Kings rally. or something. A cape? Was it a cape? During her deposition under oath, Carol falsely denied that she received litigation funding from an outside source. We know she did. But later, she admitted that the anti-Trump maniac and the guy who went to Jeffrey Epstein's island several times, we believe, billionaire Reid Hoffman, was financing her case. And he hates Trump too. Now, the district court in error declined to continue the trial or order an adverse inference due to the late revelation. She's like, oh yeah, I am actually getting funded by all these Democrats. Hoffman has stated that he would spend as much as he possibly can to avoid another Trump presidency. And how'd that work out there for you, Reid? Hoffman's plan failed. Just be an honest person and just, have good policies and you can win elections. You don't have to fund psycho ladies to create lawsuits against your political opponents. Maybe just be a good person for once. There is more. Carol admitted that she coordinated with her two outcry witnesses, Carol Martin and Lisa Birnbach. We both listened to them testify before publicizing her false allegations. She shared a draft of the book. She said, hey, I'm going to publish this book. Do you think you guys can back up my fake story? Even worse, Carol communications with Martin reflect a deliberate plot to slander Trump. In an email to Carol on November 11th, Martin described Trump's recent election victory as an apocalypse. They're all crying about it. Express, we have to do something to stop the train. No, there are no brakes on the train. We're not stopping. Just be good people with good policies. You don't have to create lawfare and sue everybody. Then on September 23rd, 2017, in an email that Carol did not produce in discovery, and why should she? There's not going to be any consequences from it from the federal judges. By the way, these are the same federal judges that were watching undermine and usurp executive power every day these days. Every day we're waking up. It's like, oh, another judge, another lying hack judge. Oh, 12 of them went and talked to the media and said, the Supreme Court doesn't have our back, and cried about that undercover while they're in the gutter, not acknowledging who they actually are because they're cowards. Remember that? So it's constant. This was all happening back then too. This is not a new phenomenon. It has been happening since the beginning. And then the media would come back to us and say, well, Trump was, found liable from a jury in a federal court. Okay. From Judge Kaplan, and allowing all of this garbage to go on. Yeah. All rigged. Okay. And it's been the same. We cover it every day here. But it was happening way before Trump won again. This was all back in the 2020s when they were trying to take him off the playing field permanently and then shot him in the head. Then on September 23rd, 2017, in an email, she never produced anything. Why would she? Martin wrote to Carol, one of the witnesses, warning of President Trump's tenure. This has to stop. As soon as we're both well enough to scheme, we must do our patriotic duty again. I guess what is that? To scheme? That's all they're good at. Just be a good person. Carol replied, totally. Let's scheme and have something special for you when we meet. Martin, the witness, so-called, who was helping scheme, later testified that the something special that they would advance and their patriotic duty to in this scheme to stop Trump was, what did she say when she testified? Oh, it was a stuffed squirrel. Oh. Well, we're just going to make a stuffed squirrel and yell at it or something. That's their scheme? No, we know what the scheme was. This stretches credulity between the breaking point. This whole case did. Now, to try to buttress her implausible story, Carol also relied heavily on propensity evidence. Okay, like if Trump said something or did something, then it's likely that he did this thing. Do you have any evidence he did this thing? No, but he said all these other things, which make us believe that he had the intent or the capacity to do this thing. Specifically, the equally implausible and biased testimony of these two people, Jessica Leeds and Natasha Stoynoff, as well as the Access Hollywood grab them by the purse tape. In her opening statement and closing argument, Carol's lawyer repeatedly emphasized this improper propensity evidence. He says, you heard Jessica Leeds, you heard Natasha Stoynoff, I think it was Roberta Kaplan, tell you how he used this exact same playbook with them. They say, what? Okay, well, Jessica Leeds, let's break this down. They say, Leeds, she raised facially implausible allegations against Trump in October 2016. October surprise, more assault claims, 37 years after her alleged date, which was not identified for years, of another incident involving Trump as part of a media pile-on after they released the Access Hollywood tape. They all flipped out about it. Leeds falsely testified that in 1979, Trump, then a successful real estate developer, supposedly assaulted her suddenly and without warning, like out of the blue. He just like lunged at me while sitting next to her in the first class cabin on an unspecified flight of unspecified origin. This one's not a dressing room at Bergdorf's. It's on a airplane. Says, in Leeds telling, this very aggressive physical struggle occurred in full view of the first class cabin filled with other passengers. He just like sexually attacking this woman in the middle of first class. It was like, oh, well, yes, I'll have one of those wet towels. Sure. At first, Leeds claimed that the assault lasted 15 minutes. They came over in the middle of it. She's like, would you guys like some peanuts or some champagne while you're being attacked here? Can I refill your glass? Leeds, and then she revises it. Actually, it was just a few seconds. And then she sat there. No problem for the rest of the flight. Got off. Said, have a nice trip, Mr. Trump. At first, she claimed 15 minutes, actually a few seconds when she realizes how dumb that sounds. Leeds also testified that in full view of other passengers in the flight crew, Donald Trump supposedly tussled with her, trying to kiss me, trying to pull me towards him, grabbing my breasts like he had 40 zillion hands in the tussling match between the two of us. This alleged tussling match ended after Leeds supposedly stood up, stormed away. At which point Trump, in full view of other passengers, was also supposedly standing up, lunging at her from the window seat into the aisle, and no one said a word, including her. This whole thing happening in the first class department. Everybody's, wow, this is really interesting. They must be in a little argument. Now, she admitted, they said, well, this is strange. How come nobody else reported this? You didn't file a report. Can you even tell us what day it was? Was he even on that flight? Can we prove that? Can you validate that? Where were you coming from? Where were you going? Let us cross-reference it. None of it. Just on some plane sometime somewhere. Now, then she admitted she is politically active. Oh, guess what? She's a Democrat. Yeah. Who donated to Democratic Senate candidates and obtained a Hillary Clinton campaign button for her daughter. Yeah. She conceded that she hoped her story would literally influence the election against Trump. Much like Carol, she could not recall the origin date or flight, making it impossible to verify or falsify her story at all. Just check the records. See if did you sit next to him? Or are you just a liar? And we don't believe all women, okay? And we don't believe that women should be attacked, obviously. And if something like this happened, then that would be a reprehensible thing. We would say absolutely ridiculous. And, somebody should be in jail for that because we don't believe that that should happen. But women who come out and just want to scheme around with their colleagues because they hate Trump and then lie about it. And then also just pull stuff out of their butts because they are Hillary Clinton supporters and got a button for her daughter. It's no different than any of the juicy Jussie Smollett being attacked. This is MAGA country. All made up. They're crazy. And the judges entertain it. And you say, hey, can we cross-reference you? Can we challenge this evidence? No. How dare you? This should come in under the rules of evidence. And the judge lets it in. Now, here's another one, Natasha Stoynoff. Her allegations suffer from similar credibility problems. She claimed that in 2005, Trump suddenly grabbed her shoulders and kissed her without her consent at Mar-a-Lago within a short time of his then pregnant wife and many others, within a short distance, right in front of everybody during a break in her interview with both Donald and Melania Trump. What? All right. Saying, yet directly contradicting her later claim of being assaulted at Mar-a-Lago, shortly after the incident, she wrote a glowing profile of Donald Trump and his marriage in People magazine without any suggestion of anything problematic at all. She's like, oh, I forgot I wrote that piece where I said it was an amazing time and I enjoyed everything. Well, what I meant was he attacked me in front of Melania. What? Stoynoff wrote that Donald Trump enjoyed marital bliss, that his wife was glowing, and that he reveled in being a twosome, and that he is romantic but very private, and that Melania expected that he would be a fantastic dad. She made no accusation against President Trump until 11 years later, right in October 2016, weird, when she suddenly joined the media feeding frenzy after everybody was Access Hollywooding themselves to death. And this was in the aftermath of Weinstein and the rest of, really disgusting people. They're like, oh, perfect. We'll just make Trump like them. Like Carolyn Leeds, Stoynoff is politically hostile to President Trump, testifying that she viewed him as terribly unfit and that she was happy after the 2020 election. Interesting. So her fake story was great, elevated her status, and completely incongruent with her prior publications when she was writing as a journalist. Didn't mention that. Wouldn't that be a pretty big story? And did they have cameras rolling saying Trump attacked her in the middle? There was a break in her interview. And so they're all sitting there on the couch and he just lunges over there and tries to make out with her. They didn't have that on camera? Apparently not. That would have been a big story, but it wasn't because it didn't happen. Here in 2019, Trump, through official White House channels, when he was the president, okay, we have presidential immunity that they didn't consider, denied false allegations against him. It got published in New York. They were attacking him after winning because they needed to pull out all the stops so 2020 wouldn't lose again. He made these statements from the White House in response to press inquiries as a matter of public interest. And the White House press office distributed his statements, and he's allowed to do those things. It's part of the purview of the presidency. The defamation action that she filed against him is known as Carol 1. But this is related to Carol 2. Okay, there are two of them. I think at the outset of the show, I inverted them. But this is Carol 2. She brought this one in 2022 against President Trump. Once they extended in New York, she helped to pass and change literally the laws that allowed her to sue. So in 2022, New York Adult Survivors Act, they say, we're going to extend the statute of limitations on this. You can now bring claims within this 1 year safe harbor window. And so bring your claims and then they'll close back up. So if you've ever had any prior claims, just come bring them. And her attorney and her were literally involved in petitioning to have that law changed. Kathy Hochul brought him out. They had a full press conference. Trump has consistently and unequivocally denied the allegations in both cases that there was any actual assault and that he defamed her. Now, Carol 2 proceeded to trial first because Carol 1 was delayed about immunity and whether the United States should be substituted in. Very complicated case history here. And so as a result of the significant evidentiary errors that we have raised here, Supreme Court, Carol came out and she got $5 million in Carol 2. Now, based on incorrect findings there, the district court then wrongly applied issue preclusion in Carol 1, meaning you don't need to relitigate what happened in Carol 2. So we've already settled that in Carol 2. So we're going to just bring that back over here. And then she got a second judgment. This prevented Trump from contesting the merits on the original case. She then got an unjust judgment of $83 million, okay, in Carol 1, plus the 5. And we looked at the numbers on this. Remember, I forget what the total numbers were. But she, I believe, made more from Trump's lying about her, like 10x more, than the actual, the thing allegedly that happened, that the jury said did happen. Says on November 5th, in other words, lying about a woman, according to the jurors, is worse and more expensive of a mistake than actually grabbing him by the purse. On November 5th, the Second Circuit called for Carol to respond to 2 petitions. We appealed it. And of course, the courts of appeals denied it. On appeal, Trump challenged the admission of some evidence, said she never should have come in. The Second Circuit, though, rejected Trump's arguments cursorily. Quickly, they just didn't care. The panel erroneously upheld admission of Lee's testimony, and they said, well, it's a federal crime to commit assault on an airplane, so that's good enough for us. Like, what airplane? When? How long ago? Where were they coming? Where were they going? What's the proof? The panel also erred. They upheld her testimony after concluding that the sufficiency standard of admitting evidence is much lower than a conviction, so we can just let all this in. They also let in the Access Hollywood tape, and they also relied on legislative intent. They said, well, what did the legislators actually say? Versus what does the law say? Trump sought a rehearing. We had one dissenter who came out, and the judge was good. He said the Second Circuit denied this, but one judge was dissenting. As Judge Menashe explained, the panel embraced a series of anomalous holdings to affirm the lower level judgment. The panel opinion upheld the testimony of these two, Leeds and Stoyanov, by relying on statements in the congressional record to alter the effects of the rules. There is every reason to believe the testimony in this case would have failed standard Rule 403 analysis, the balancing test, saying It's way too harmful than it is helpful. It's not answering any of the actual allegations brought by E. Jean. She said these things happened. Does that testimony help us determine whether this happened or not? No. It just says that Trump did something to them in an entirely separate incident. But they still brought it in anyways. It's like, oh, you robbed the bank. Oh, you robbed the bank. You robbed the bank. Okay, but you have no evidence that I robbed this bank. Too bad. You robbed the other one, so it kind of has all the hallmarks of guilty, and so you're guilty. It says, in affirming the district court's admission of these two, the panel allowed conduct which does not meet the standard to qualify as an attempted assault. And by affirming the admission of the tape, they also erroneously sanction the admission of evidence of prior conduct to prove or corroborate this culpable conduct. And in the dissent, the judge said, these holdings conflict with our actual precedent. We can't interpret evidence that way because we've held previously we can't do that. And this produced a judgment that cannot be justified under the rules of evidence. The result was a jury verdict based on impermissible character evidence, right? You want to prove people guilty, not because a bunch of people come in and say they're bad people, but because you have evidence that ties them to the crime. Otherwise, that would happen all the time. You'd have a show of people coming in, that guy, he doesn't even return his shopping cart when he's done. Jurors like, oh, friggin' guilty. Hate that guy. And you're like, there's nothing to do with this. But he's a bad person. He attacked an airplane lady. He attacked some other, whatever. No one can have any confidence that they would have returned the same result if that evidence, which is way too prejudicial, not helpful at all. It doesn't help answer any of the claims. Did you see Trump attack E. Jean Carroll? No. But he attacked you? And they said, well, it's close enough, so we'll just count it. Now, Carroll's trial also rested on fundamentally improper propensity evidence that courts ordinarily disavow. Can't come in. It's useless evidence. To greenlight the admission of such troubling evidence, the Second Circuit actually created and deepened significant circuit splits in order to make this charge stick. This court should grant the petition. We need to ensure uniformity across all of our circuits, and if misapplied, they're going to wreck it. Now, as you have explained, Supreme Court, before, the American legal tradition has long rejected reliance on propensity evidence. Okay, it's evidence that is generalizing an earlier bad act into bad character, and then saying he did it now. Reliance on that undermines the principle a trial should be about the crime, not what sort of person the defendant is. We understand this concept. They enacted the federal rules of evidence. They say some allegations can come in by their own terms. It's not automatically admissible. We have to go through a deep assessment of the evidence. The circuits have taken various approaches on this, and there's a serious circuit split here. Some circuits, including our Second Circuit, have endorsed a truncated Rule 403 balancing test analysis. And they reject the rules, and they're instead relying on legislative history, which is history. It's not written in the rules. So in applying the Rule 403 evidence, the balancing test to propensity evidence, the circuits have taken different approaches. We got 1st, 7th, 10th. They've correctly held that it's the same analysis across any evidence coming in. But other circuits are saying no. The DC and the 5th Circuit have not even acknowledged this conflict, but by contrast, the 1st, 2nd, 3rd, 4th, 6th, and 8th seemingly have instructed the lower courts to apply Rule 403 less stringently and allow more evidence to come in that should be barred. Explaining, this wide circuit conflict has resulted in significant differences across the country in how evidence is handled. In evaluating this, the rule would focus heavily on the remoteness in time of the other act. Okay, like these are like 37 years ago, the one airplane lady. Remoteness in time reduces the reliability. And the propensity evidence against President Trump was old. It was based on allegations about incidents that supposedly occurred 44 years ago and 18 years ago. All of it before even E. Jean came up with her claims from 25 years ago. In addition, these incidents were separated by many years from Carroll's facially inconceivable encounter, which supposedly happened in 1996, a day which she couldn't recall forever until suddenly in the trial. Oh yeah, I remember. Thus, as the dissenting judge in the Court of Appeal said, he observed, had the Second Circuit actually applied the proper standard, it would have excluded that testimony. or it would have issued a decision at the outer boundary of how this should come in before it hits the jury. But the Second Circuit erred in concluding that old testimony, old remoteness, it doesn't matter. They said, who cares? We need this evidence. The court then found that evidence was sufficiently similar in material respects, so it's probative, which is such a dumb standard. It's like, well, it sounds pretty good to me. Sounds similar, so we're going to let it in, and the jury can decide. Finally, the Second Circuit dismisses remoteness. The Eighth Circuit has also dismissed remoteness. And in contrast, other circuits have said you can consider remoteness. It's very, very important. But they rejected this. And what they did is they relied on this one statement from one representative called Susan Molinari. They're going into the legislative history. What does the law say? Well, the law says we have to do something that we don't want to do. Okay, great. Let's ignore the law. What is the legislative history? What did the people who wrote the law say? Let's use that instead of the actual law, which is what they did. This court says you can't do that. All statutory interpretation begins with the text, okay? Don't look at the history. Look at the law. What they write. That's how you govern a country. The absence of any language that eliminates remoteness balancing cannot be squared with other modifications and other rules of evidence. Now, instead of grounding its analysis in the text, they didn't care. They went out and they went to find sponsors of the legislation and other nonsense from the remarks of the representative. It's not the law. They even talked about Senator Bob Dole, and they went to law review articles and all this stuff, but it doesn't matter. The murky waters of congressional record don't help us interpret anything. And what you're doing here is trying to deepen a split by digging into that. The rule's very clear. Just interpret the rule appropriately, and we can put this to bed. Now, in cases alleging an assault, there is some admission components that a party committed an assault. There's an exception for that. Well, what about this? We can talk about this if it meets these standards. The act must constitute a crime to meet the two requirements. The act must constitute a crime, and the crime must involve at least one of the categories of conduct that's enumerated. Now, Trump was never investigated, let alone charged with any crime relating to any of these people at all. It's just their statement. Well, I was attacked. Okay, well, where's the evidence? Well, it's my testimony. Can we corroborate any of it? No. Okay, well, we need more than that. The district court erroneously concluded that Leeds falsely alleged, and Trump has denied, it's he said, she said, all of it came out years after, 15 years, 20 years, 44 years, you saw the numbers. Rather than defending this erroneous holding, the Second Circuit created an alternative theory. Nobody even raised it. They just pulled it out of their butts. That Trump's alleged conduct would have somehow violated 18 U.S. Code 113. They would have called it simple assault. And that simple assault incorporated the common law definition of assault, which required no sexual element. And so unsurprisingly, then simple assault counts, and they could bring all the evidence in. Trump said, you guys can't make stuff up on the fly because you hate my guts. The Second Circuit said, yes, we can. We're the Second Circuit. And now we're at the Supreme Court. First, the definition of this turns on whether lots of technical stuff we'll fast forward through. The rules define these things in this way. Under this approach, the statutory definition includes offenses with elements that entail deceitful conduct. And so their exception doesn't fit here. As Judge Menashe in the dissent explained, crimes that neither prototypically nor actually involved criminal assault still qualify as admissible evidence. This would not be a realistic assessment, though, of congressional intent. It requires the court to do more analysis, and the testimony that came in were neither crimes nor assaults, but they let the testimony come in anyways because they really wanted it in. But this is erroneous. Supreme Court, you got to step in and fix this. And we also have the Access Hollywood tape coming close to the end here, saying the federal rules of evidence also say we don't want propensity evidence in. Like, you robbed the bank before, so you definitely robbed the bank this time, even though we have no evidence of that. The rule says under 404B that evidence of any other crime, wrong, or act is not admissible to prove a person's character in order to show that on a particular occasion they acted in accordance with their character. Well, you see, you are a bank robber because you've been convicted of that, so we think you're a bank robber now. No. At the same time, it also does permit someone to show, well, there could be some prior bad acts that can come in if you're trying to prove motive, opportunity, intent, preparation, plan, knowledge, identity, absence of a mistake, or lack of an accident. So there are some propensity evidence that can come in if you're trying to prove one of these other things: intent, opportunity, motive, knowledge, identity, these different things. Very specific analysis that goes on in those cases. Now here, they said that the Access Hollywood tape was properly admitted under one of those exceptions. The Second Circuit, though, did not cite any of the non-propensity purposes. So in other words, you're using the propensity evidence to show that there was a plan, or they had intent or knowledge of the plan. You're not using the evidence to say that they actually committed the crime. It's to show some other aspect of the crime. They say they never pointed out what else they were trying to prove. Instead, they claimed the tape was a modus operandi, which is not in the statute at all, which is interesting, and to corroborate testimony by allowing admission of this without requiring the evidence actually be tied to the rules. It conflicts with other circuits. And so they created a new modus operandi. It's not in the rules. You just read it. It's not in there. However, the courts have recognized a modus operandi can offer one way to accomplish one of the purposes. So for example, you could use that to establish identity or one of the exceptions, but that's not what they did. And so the courts are interpreting the rules differently. And this case didn't involve any of those exceptions. We didn't need the evidence to show identity or intent or absence of mistake or lack of accident. In fact, Trump has continuously and steadfastly denied that the incident ever occurred. And so any modus operandi evidence didn't serve any other purpose of non-propensity evidence. It was just to say Trump attacks women. The only reason that Carroll sought to admit this tape was to argue that if Trump had allegedly engaged in bad acts on other occasions, it's more likely that he did it here. Now, the purpose was solely to be prejudicial. And the rules say if it's more prejudicial than it is probative, you got to kick it out. And there was no exception under the 404B standards. And so they should not have done that. The Second and the 10th Circuits, there's a split. As we know, we've talked about all the differences repeatedly here. But now this Court of Appeals also directly conflicts with the DC Circuit right next door. The Second Circuit did not link the alleged corroboration to an otherwise improper purpose, instead wrongly held that the corroboration itself was a proper purpose. And so this is a mess, Supreme Court. We need you to come in and correct it. Therefore, President Trump respectfully requests that you grant this petition and weigh in on this case. The evidence should never have come in. This whole trial should never have happened because it was concocted by the Democrats, both trials. We covered it all here at length, and we are going to continue to do so until hopefully the Supreme Court comes back down and vacates these verdicts ultimately in the end. And I think that they can do that or order a new trial or whatever. But as it stands, this is just one component. And if they win this one and they say that evidence was bad, it's going to parlay into the other case. And so although this one's about the $5 million judgment, a victory here will compound into the other cases, and we'll see the $93 million judgment hopefully evaporate. She's not entitled to a dime of that, in our opinion, because this all seemingly was created by Democrats. We remember that E. Jean Carroll had a conversation with George Conway. They were at Molly Jong Fest party doing something. They said Reid Hoffman will fund the whole thing. And you're crazy, so you're great. You can do whatever we tell you to do. And then she went on Anderson Cooper and she said, a lot of women like to be hard. You know, Anderson, you're fascinating. And he said, commercial. But now the Supreme Court will hopefully weigh in. And I think they have to take it. I mean, if the circuits are that split this badly because the Second Circuit tried to rig the case against the president because they hated him so much, they got to take it. They've got no choice. We'll keep our eye on it. Hopefully the acceptance comes soon. We'll have oral arguments on it, do the whole thing. We'll be here. Thank you for subscribing and joining as we do. All right, now we've got more updates. We're going in. Let's do the Comey case, and then we're going to have whistleblower updates from Christina Bobb at the end. But here is what is happening in the James Comey case in court. James Comey and the prosecutors continue to battle over discovery and evidence. James Comey really wants to get his hands on these other materials, And there are a lot of questionable things going on here because the attorneys who are representing James Comey, one of them is this guy called Patrick Fitzgerald. And we now know that there were other search warrants that were executed against James Comey years ago, before this case was even filed, before Lindsay Halligan got even appointed in the Eastern District of Virginia. And Comey wants to review those materials, but the problem is James Comey apparently was also sending emails and classified documents to this same guy back at the time around the allegations of the lying. So this guy, Patrick Fitzgerald, was appointed to be James Comey's special counsel at the FBI, and then was also his attorney to whom he was getting documents sent from James Comey and to others, including Daniel Richman, who is the guy who was supposedly, allegedly leaking to the media. And so we've been battling for a while now over grand jury materials, and a bunch of stuff was just submitted under seal. So the DOJ Trump prosecutors have now submitted ex parte, which means Comey doesn't get to see them, under seal documents and audio files. The judge is going to review those and then make a decision what comes next. But there was a telephonic hearing that took place yesterday, and let's go through the transcript on this so we can see what's going on. Not a long hearing. They all called in telephonically. James Comey was on the line, and here is some background here. The court says, and these are federal cases, so we don't get to see any video ever, but the court said, good afternoon, everyone. This is Judge Fitzpatrick, hopefully no relation to the defense attorney. And we're on the record in United States versus Comey. Who do we have on the line here for the government? Good afternoon, Your Honor. Gabriel Diaz and Tyler Lemons for the DOJ, Your Honor. All right, good afternoon. And who do we have for the defense? Good afternoon, Your Honor. Rebecca Donalski, Patrick Fitzgerald, Jessica Carmichael, all here for the defendant, James Comey, who's also on the line. All right. And everyone, who do we do have a court reporter who is transcribing the proceedings. Shout out to Diane. So please speak slowly and please identify yourself before the government defense. The government has requested that I review some materials in camera, which is in chambers off the record. I appreciate that's the position the government takes. It seems to make sense to me. What's your position? Defense attorney. Thank you, Your Honor. We also appreciate the suggestion that you review these things, but our view is that the defense is best positioned to determine whether misconduct or irregularities occurred, and whether those would be a basis for a motion to dismiss the James Comey case. First, the defense is most familiar with the defendant's attorney-client privilege, and we've got questions whether that privilege should still exist or whether or not the defense attorney who was receiving Comey's emails when he was still the director or just getting fired from the director, whether that makes him a witness in this underlying case. And the materials at issue. And second, the defense is best positioned to identify where the evidence came from. And so we want to see this material. Now, that being said, to the extent that there can be an ex parte submission from the defense with respect to what we've been seeing in the warrants and the privileged materials, we're open to doing so. But our view is that we've cited case law to this effect, and the defense is really best positioned to do this. So we want to see all of the evidence, even the grand jury proceedings, which are all usually under seal. All right, says the judge. So in terms of an ex parte submission, what do you envision? Like specifically, what would you be referring to that you want to see? Well, Your Honor, I'm referring to materials that we believe are at issue with respect to Comey's privilege. We've now seen what the agent saw from the materials obtained pursuant to the Arctic haze warrants that were not reviewed for responsiveness and that are clearly privileged. Okay, Arctic haze is different than Arctic frost. Arctic frost is the investigation into Trump. Arctic haze are the FBI's investigations into the leaking of their investigatory work to the media. Guess who was leaking to the media? James Comey via Daniel Richman. And Arctic haze was the FBI really just playing with themselves. It's pretty disgusting. They opened like 7 investigations into themselves. Why are all these leaks happening? Where are they coming from? Turns out James Comey and the FBI, like the top people at the FBI. So they say, okay, we've now seen those and we've been wondering what those old warrants were, and that's what they were for. So that's one aspect of the submission. Now, the second would be, and of course, they investigated themselves 7 times and they found they did nothing wrong. The FBI, they're so dumb or malicious that they opened 7 investigations. Think of all the copy paper they wasted. They couldn't even find it. What was going on? It was Comey. He's like right next door in the office, sending stuff to Daniel Richmond. The second would be outlining what we've seen in terms of the materials that were produced by the government. And so we want to see the search warrants and more. All right. And when would you be in position to file this submission? Well, we could do that by tomorrow. All right. Prosecutors, any thoughts? Your Honor, we could provide the grand jury materials to the court in camera to you. I'm not sure what the ex parte submission is going to be on the defense's side. Like, what are they going to give to you that we can't see? But again, it seems that they are talking about information that would be attorney-client privilege or possibly gained, as they say, in violation of the Fourth Amendment. Now, neither of those two issues go to whether an irregularity occurred in the grand jury proceeding. That would be a basis for the dismissal of the indictment, meaning that something that occurred before the grand jury was so bad we have to dismiss the case. We cited several cases in our additional briefing that we filed before noon today. We don't believe that either of those issues would get them to be able to dismiss the indictment. And so we should not give the grand jury materials to James Comey. All right, says the judge. I understand that, and I apologize. I think I said Mr. Lemons. I'm getting to know you all very well. I think that was Mr. Diaz, correct? I apologize, Your Honor. Yeah, this was Mr. Diaz. All right. Judge says, and I understand your position. And the question before me right now is really a very narrow one. Whether or not there is a basis under the rules for the court to make particularized findings necessary in order to require disclosure of the grand jury proceedings. So I think any ex parte submission that is limited to that issue, that is limited to that question would be welcome. And I'll determine what, if any, weight to give it. But I do think review of the grand jury materials in camera, myself or the judge only, would be helpful and would put me in a far better decision. So I'll grant the government's request and I will accept those materials. Defense. Well, he says to the defense, I was hoping to get an order out as quickly as I could. I know everybody's really busy these days, but defense, when can you file? We can do it as soon as possible. How about by noon? That's fine. That's fine. Prosecutors, when can you file the materials? Your Honor, I could file the materials shortly after this hearing ends. If you wanted the audio version, I could send that electronically too. Listen to the whole thing. I'm not sure if I could file it, but there's a way to get it to your clerk. I'm sure we could do it within a few minutes after the hearing, sir. All right. Okay, says the judge. That's great. I'd ask that everything go through the clerk's office, provided to them. And again, just to be clear, when we talk about grand jury materials, Mr. Diaz, we're talking about, at least just for the in-camera review for the judge, all materials up to and including how the grand jury was instructed. Any other questions, comms in addition, right? Yes, Your Honor. We also have 14 exhibits that we can provide, which we may have already seen. Honestly, they may have released those in that motion, the response to the vindictive prosecution motion. Okay, says the judge. All right. Well, I'm going to enter an order to that effect, and I'm going to consider the ex parte submission. I'll review all the materials, and I'll get an opinion out as soon as we can. Does that work? Thank you, Your Honor. Thank you, Judge. All right. Anything else from the government? No, Your Honor. All right. Defense. Anything else? No, Your Honor. All right. Thank you all for taking the time to get on this call under such short notice. Have a great day from the judge. All right. So we had that hearing take place. The judge did come down and issue an order, and we had that order come down. He says, this matter comes before the court. On November 7th, the undersigned ordered me, the judge, that a telephonic hearing be issued on November 4th. We said any party who wants to submit additional briefing, do it. At the hearing, in its motion, the government said, let us look at things. And so I will. It is now ordered that I will do an in-camera review, and you shall submit your filings before the end of the day tomorrow, before noon, signed by the judge, William Fitzpatrick, who's handling the preliminary stuff in the Comey case. Now, here's more. Here was the additional briefing that came in from the DOJ. Okay, so Trump's attorneys, the prosecutors, are saying, don't give this guy any additional access until you look at it. They say, all right, look, defendant Comey speculates that the government may have submitted evidence subject to suppression, like they can get rid of it, or attorney-client privileges to the grand jury. He says he needs access, though, to decide whether or not that happened. But as we know, the grand jury rules have a long-established policy of maintaining secrecy of these proceedings. And the rules say he's not allowed to just search for evidence to see whether he can dismiss these things. Instead, he must produce a particularized, factually based evidence that shows where the problem was. And then he can make an argument for a dismissal. But right now, it's only conjecture. Second, even assuming he could prove that we violated his Fourth Amendment or attorney-client privilege, if those errors occurred, it's still not a basis to dismiss his case. But even so, go ahead, take a look. We say you should look at this, Judge. Look at the in-camera proceedings so you can confirm the baselessness of his claim that we shared anything with the grand jury at all, okay? We're above board here, Judge. Look at the files. We'll send them over. In fact, on October 13th, we moved for a filter team. He opposed that motion. He said, we just want the information. Give it to us, rather than having a filter team confirm whether there was any problematic materials in there. The court noted, we had a couple of briefings, a couple of hearings on this. Then we had the defense. Comey came out and they said, well, we want to know if these prior warrants from 2019 and 2020 had undergone a responsiveness review. And defense counsel said that if the government had accessed both responsive and non-responsive materials, that would clearly violate the Fourth Amendment. So what did you get from the warrants and what did you look at? The judge asked the defense counsel, what information do you need that you don't have in the file to file a motion to challenge this? He says, well, what does the government have? What did they access and provide to the grand jury? The judge is now going to look at it. But they say he can't look at this material. The principle of the grand jury independence is firmly rooted and protected in our federal system. And we had a great question on this come up. Where does this come from? And we've always just followed the rules. It's in the Federal Rules of Criminal Procedure, Rule 6E. That was codified in 1944. But before that, right, defense attorney, oh, just follow the rules. Well, you say, well, it came from the Fifth Amendment. Okay, you can't be charged unless an indictment is presented to a grand jury. So, well, where's the grand jury come from? And what's so interesting about this is even before we had the Constitution, we had this practice that comes from English common law. And I was looking into this and I was asking myself, well, why do we have that here in the United States? Because oftentimes it feels like we should see the underlying evidence that was presented to a grand jury, especially in cases of public interest, because isn't that a lot of evidence is presented there? For example, in the Jeffrey Epstein case, he's dead. He got indicted, but we can't see any of the evidence. It's all under seal. Why? Why is it so secret, right? Well, there was an interesting case. Our founders were in favor of this, and it emanates from the crown, from the English crown. They, if they could see if they saw what the prosecutions were, and the process wasn't secret, then the crown would influence the prosecutions. And so we started to develop this secrecy, and it translated over to the United States. There was this interesting case of John Peter Zinger. A little bit of a tangent here, but this was interesting. John Peter Zinger was in the early colonies. He was a German printer and a journalist. He was in New York City. And he got charged, okay? He came out, starts running his mouth like we do here in 1734. Before the Declaration, before the Constitution, all the things. He was libeling, they said, the royal governor of New York, okay? The English. But the jury acquitted him. And he became a symbol of freedom of the press. And what's interesting, a grand jury that was independent and separate from the crown refused to indict him. Okay, so in other words, the secrecy of the grand jury is kind of baked in. In 1734, he gets arrested. The sheriff arrests this dude. He's voicing opinions critical of the colonial governor. Grand jury of anonymous people, nope, no indictment. Attorney General Richard Bradley charged him later with a different crime. So then the crown actually charged him directly because his own people wouldn't indict him. And he was acquitted. They said, truth is a defense. This guy's a piece of work, William Cosby. And he was acquitted. So the grand jury proceedings, but even back then, before our Constitution was even formulated, was to create some distance from the crown so that the crown couldn't know what was going on and couldn't intervene in the process. So creating a little bit of separation there. And then also when you look into it, there's the other reasons that we all learn about to protect the witnesses, to protect the innocent. Okay, there may be other people who came up in the proceedings, other co-conspirators, other people who helped to create the indictment, who may be charged or may be cooperating witnesses, and you want to keep that all under seal until the trial. We also want to preserve the trial integrity. You don't want two trials, one that's done publicly before the trial happens, after the grand jury proceedings are released. And of course, this concept that investigations are not prosecutions, right? So a grand jury is part of the investigation. There may be other people who are going to be indicted. So we keep it all locked down. Now, Comey wants to get access to it so he can start to formulate his defense and see what else is out there and really make an argument that they screwed something up and then use this to dismiss the entire case at the outset, at the very beginning, right? We haven't even gotten far in this case, but they say you're not entitled to access. You don't get these materials. His desire to review the grand jury material is insufficient just because he wants to. It's been long established. It's indispensable. We have very secretive grand jury proceedings. This was codified in the federal rules of criminal procedure. And if you move for disclosure of this, you better have a good reason. You have to have a particularized need for the info, a blanket request for all the information. And see all this case law, case law. It's very well ingrained in our law. And now Comey, he's suggesting that he needs to know what evidence was before the grand jury so that he can challenge the use of the info that was seized from 2019 and 2020 when he was actually leaking to the media, in our opinion, via Daniel Richman. But he has to follow the rules. He has to show a particularized need. He hasn't done that. He doesn't get to review secret grand jury materials to try to mine for gold and find something. The rules say he's got to have more, and he's not doing that. Here, he was provided with 2 affidavits by 2 FBI special agents who possibly reviewed privileged materials. As their affidavits indicate, neither agent was involved in the grand jury presentation, so no privileged information was presented to them. And by suggesting that he needs to see this, he's turning the rules on its head. The rule doesn't permit a defendant to just go in and gobble up whatever they want. You can show that a ground may exist, but Comey can't, because neither a Fourth Amendment violation nor a privilege violation is a basis for a total dismissal. The Supreme Court has applied all these rules in Calandra, in that case, in Lawson, in this case, in grand jury proceedings, in this case, and on and on and on. United States versus Colasurdo. Rodolitz. Also, even Comey now, he cannot show that he needs this. And so we can't give it to him. Even assuming he could show that we did make some violation of the Fourth Amendment or attorney-client privilege. And to be clear, he cannot. The remedy would be to suppress that evidence at trial. You don't dismiss the indictment. That evidence just wouldn't come in and the case would move forward. Now, although a grand jury consideration of privileged material is not a basis to dismiss this, if there was outrageous government conduct, maybe that could show a basis for this, but none of that has happened here. These are all speculative claims of some violations, and all of it is insufficient to compel us to give over the grand jury material. And even so, we'll give it to you, Judge. And the judge said, we'll take it. We're going to show you, we're going to give you these materials and show you that Comey's whining is completely and utterly baseless. Signed by Gabriel Diaz, shout out, on behalf of Lindsay Halligan's team in the Eastern District of Virginia. So this case is marching forward. We can see that the judge's final proceeding minute entry says, this matter came for a status conference. The court now requests the defense submit ex parte any information so I can look at it. They said no problem. The court requests the government also produce anything related to the grand jury, orders to follow. And of course, we read it. So the Comey case marches on, and we'll see what the judge does now that they got those docs delivered. You can see Trump's DOJ filed those minutes right after, audio files and documents received. So we'll see what the judge says, but we're learning more and more about this case. It's not as thin as they said when Lindsay Halligan first brought the charges, because it relates all the way back to 19 and 20, and Comey's been searched before with other search warrants, and he seems a little bit freaked out about that. All these documents now coming into the court. DOJ seems very confident. Here, Judge, his whining is totally baseless. Look at these documents, and we hope you'll agree. So we'll keep our eye on this case, my friend, of course, as well as the other Trump prosecutions happening out in the Eastern District of Virginia and elsewhere. Thank you for subscribing to our channel and joining us as we do. We got one final segment on the day, my friends. And then it's going to be time to hear from you. Thanks for sticking around on this lovely Tuesday. But here's another big one. Whistleblower bombshell. You can see this memo went over to the Department of Justice, and guess who it came from? Christina Bobb. We know who she is because she was the same person who got prosecuted by people in Arizona. Christina Bobb, this woman here, has worked for President Trump and been involved in a lot of different things, including being prosecuted by Attorney General Chris Mays in Arizona. This woman, the Attorney General here, who had a very interesting relationship revealed by Christina Bobb in this memo. And the memo was released to us via Judicial Watch. And I do believe that Christina Bobb is now working over there. So they published this on their website, November 10th. It was written earlier, June 4th of this year. Of course, Trump came in and won. But Christina Bobb has been around for a long time. We've talked a lot about her work. She was born in Phoenix, Arizona. She served in the Marine Corps. Happy Veterans Day. Completed Office OCS in 2009 and has been around a lot. Worked for OANN. During the presidential debate, she helped to fight the rigged election. She was prosecuted and has been prosecuted repeatedly and fighting back every step of the way. She was also involved in the Mar-a-Lago case and defending Trump there. And so you can see she's been around forever. So we're grateful that she is now blowing the whistle on what she knows. And she dropped this one out for all of us to read. She says, I am Christina Bobb, a former investigative reporter and attorney who worked for Trump from 22 to 24. I'm one of 16 remaining defendants in the Arizona criminal prosecution of Kelly Ward and others. The prosecution of the Trump electors, the Big Fanny case of Arizona. Now, the indictment has been remanded right now, and the court ruled that the prosecutors, Chris Mays, substantially infringed on my and my co-defendants' constitutional rights. The prosecutors at this point have not reconstituted the grand jury. They're appealing that. The court also made a prima facie showing that the case was brought for political reasons. The government is appealing that finding as well. Now, the court's rulings confirm that this case was brought for motivations other than criminal justice. And let me pause here and share this short clip of Chris Mays because she is asked about this. And here is what she says in response to what's happening next with her case.
I want to end with the next 2 weeks. You have a decision to make on the so-called fake electors case. Supreme Court has said either you appeal it or it is gone. It is over. What are you going to do?
So I'm not going to announce that on your show.
A Maricopa County judge's ruling in May delivered a serious setback to May's prosecutors. If she doesn't decide to keep going by November 21st, the Arizona Supreme Court will toss out the case.
The one thing I do know for sure, Bram, is that I am so proud of the prosecutors and investigators in the Attorney General's office, and I'm proud of the work we did on that case.
Similar fake electors prosecutions in other states stemming from alleged attempts to subvert Joe Biden's election victory in 2020 are also on thin ice.
You told me about a month or two ago when I asked you the same question in very strong terms. Isn't standing up for democracy important enough?
Exactly.
And so it sounded to me like you weren't going to give it up.
I mean, look, I certainly don't want to give it up. It is certainly not something that I want to do.
Yeah, but you're a bad attorney and you brought a bad case that should have never been brought. So it has to go away. And you and whoever this dude is over from 12 News can have your little democracy parties with each other and just have fun with your tickle fights or whatever you guys do over there. So the whistleblower continues. She says, there appears, Chris Mays, to be organized bribery in the state of Arizona and likely extending to other states as well. Probably yours too. In the course of my criminal prosecution, because she was charged by Chris Mays, the state of Arizona inadvertently disclosed information to the defense, which they have since acknowledged as authentic. Now, upon closer inspection, man, they're like, oh, here, just send the whole file. You sure? Yeah, there's nothing in there that they need, that they shouldn't see. Upon closer inspection, it looks like Chris Mays, the woman you just heard from, she got $200,000 in what appears to be in exchange for the Democratic Attorney General's Association to have prosecutorial influence through one of their initiatives called the States United Democracy Center. What is that? Norm Eisen. That was all done to prosecute their political opponents. Now, to be clear, the Democrat AG's Association, they paid Chris Mays $200,000. She gave States United prosecution power to prosecute Trump attorneys, allies, and electors. Now, prosecutors claim on the record and in emails that States United, Norm Eisen's hack group, represents their office. Okay. States United represents their office. So defense attorneys are sending emails over to the prosecutors. They're getting responses from Norm Eisen and States United. States United is a liberal nonprofit organization with whom the Arizona Attorney General's office claims an attorney-client relationship in this criminal matter. States United initiated the strategy for this prosecution, and the Attorney General's office continues to use their work product, most recently to request a search warrant, which is still pending. This is Norm Eisen's group. And let me share one of the mind maps that we have that is listing this out, which I do believe is right here. From States United. Remember this? State Democracy Defenders and States United Action. All of these, Norm Eisen's group. And remember, the way they formulate these things is they create a 501c3 and a 501c4. He also has done this many times over. Crew, Citizens for Responsibility and Ethics in Washington. Then they all get a bunch of money. A lot of it was coming from USAID and other things. And same thing, State Democracy Defenders did the same thing over there. Mark Elias has the same thing going on with Democracy Forward. And it's one just big, disgusting, incestuous, happy family over there. Pogo. It goes on and on. So it was one of these organizations is running, Norm Eisen's, is running the prosecution against many other people. And remember, they were also Norm Eisen. Yeah. The guy who led the AFL, the union's lawsuit against the president. Similar dude. Also led the FBI lawsuit, remember, against the whiny FBI agents who are like, we're emotionally traumatized by the president. Remember that? He's running the prosecution according to Christina Bobb, who is being prosecuted. And they got evidence in the disclosure from the state saying, oh, it's States United. States United claims on their website that they are an initiative of the progressive state leadership. They have the exact same address and nearly identical leadership team as DAGA, the Democrat Attorneys General Association, which is a committee of the Democrat Party. Isn't that fun? Additionally, DAGA pays the salaries of these employees, and they're sitting in the same building in D.C., getting paid from the same bank account. And guess what happened? The Democrats paid $50,000 to Chris Mays. That was back on September 5th, 2023. Oh, guess what? Her election was already over. The campaign's over. And just a couple of months after her office signed a contract that gives prosecutorial influence to States United, to Norm Eisen's law firm. The payment was also very close in time to the opening of this grand jury investigation that she created and prosecuted these people with. They then made a second payment, not just $50,000, $150,000 back over to her legal fund on July 3rd, over 18 months after her campaign had ended, and roughly a month after I, Christina Bobb, and my co-defendants were all arrested, arraigned, and publicly humiliated. Chris Mays got paid. Now, by comparison, they donated to the Arizona Democratic Party in 2022 during a campaign cycle $25,000. Okay, that's all. But that's just a donation for a political campaign. You got to boost those numbers up if you want a criminal prosecution. Okay, that's going to cost you. Yet Chris Mays and her legal fund, they received $200,000 after the election was over. But while she was developing this criminal case, that money's coming in. Now, notably, they did not make any payment to Chris Mays or her campaign or her legal fund during the election cycle. The payments only arrived after she was in office and after she got a contract with States United to participate in the prosecution. She gets her campaign funds filled. Now, DAGA, the Democrat attorneys, They benefit from the prosecution of all of these political opponents. The prosecution chills the willingness of Republicans to challenge elections, or else they're going to be prosecuted. As we've seen, people are skittish as hell. Nobody even wants to talk about the alleged pipe bomber. We're going to get sued. I know, it's because these people are maniacs. They will co-opt the government to lead prosecutions. States United, as an initiative of DAGA, has an inherent conflict and cannot impartially participate in the prosecution of their obvious political opponents. Chris Mays had an obligation to disclose that the organization that she hired pro bono to advise her on prosecuting Republicans is an initiative of the Democrat Party. Instead, she tried to cover it up. And we want to know if this same thing was happening with Fannie and Alvin and Letitia and the rest of them. States United was exposed as assisting in this prosecution only due to an error. The prosecutors now claim that their involvement is privileged and they're refusing to disclose their activity. So state attorneys general are hiring, I would presume it's much broader than Chris Mays, Democrat nonprofits, outsourcing their prosecution to these nonprofits who are Democrat organizations, then funneling their results back to the people with power, who the Democrats help get elected to go after their opponents. Could Attorney General Mays have received 2 payments totaling 200 Gs for an unrelated purpose? Yeah, maybe. But there is a significant appearance of impropriety when 1, the payments come after Chris Mays is in office. 2, Mays gives a level of prosecutorial authority to them. 3, an initiative called States United of the paying party, the DAGA. And 4, the payments just so happened to be right around the same time the grand jury investigation is opened. And then arrests were made of that very group's political opponents. So the next logical question is, will there be a third payment if she gets a conviction? These actions raise serious questions of criminal activity. My attorney and I, Christina Bobb, have prepared a motion to disqualify her office, and States United from continuing this prosecution. And we're probably going to file this soon. The portions of that motion that are relevant to this are included below, beginning on the next page. She writes here. Now, the Attorney General does not dispute their relationship with this organization. In fact, they continue to evoke attorney-client privilege every time we ask about this. She claimed on the record that the States United organization is representing Chris Mays in this criminal matter, and all their communications with the liberal nonprofit are covered by attorney-client privilege. Can't even see what Norm's arguing they do. To support their claim, they produced a contract that was signed by Chris Mays' chief of staff on behalf of the AG's office. Prosecutors claim this is an engagement letter, but it doesn't identify any attorney licensed in Arizona with whom they claim privilege. The signature block on the contract is not an attorney licensed in Arizona. In asserting their position that they have attorney-client privilege, they sent an email. They said this to Christina Bobb and her attorney. They said, as discussed, the state did not intend to provide the July 25th memorandum, okay? Instead, the state only intended to provide a publicly available memorandum from States United. However, because it was submitted and relied upon by the court, it was properly disclosed. However, the state maintains this is not a waiver of our attorney-client privilege, and we will not provide any additional information from States United because of attorney-client privilege. And so get bent. We're going to outsource our prosecution to Democrat organizations and not even tell you about it. Then when you catch us, we're going to say, how dare you? Ms. Bobb disputes that there is any lawful attorney-client relationship. The AG's office maintains that States United, Norm Eisen's group, represented the AG's office in preparation and planning of this. It's also true that States United has provided legal services furthering this prosecution despite never having entered an appearance on the case. And according to the memo, they also created a blueprint for this prosecution. The contract between the attorney's AG's office, Chris Mays, and Norm Eisen's group was signed May 15th. The memo was then produced July 25th. The memo outlines the charges, and her office is continuing to rely on their work product. Now, Norm Eisen also launched States United. It was originally called the Voter Protection Program right after 2020. He did this, quote, to monitor every pressure point to ensure Trump could not overturn the election results. Norm Eisen is a prominent Democrat attorney who served as Obama's ethics czar and then as the ambassador to the Czech Republic. The attorney in the law firm Listed on their tax form, guess what? Mark Elias, democracy docket dude. Another prominent Democrat attorney who just goes after Republicans constantly. The organization was founded as a partisan effort to stop Trump. Now they're running the prosecution. They've openly called for punishment of Trump's attorneys, and Miss Bob has been one of the victims. Now, on their website at the bottom of the page, there's a notification that says this is nonpartisan. But if you examine their tax filings, this is basically a committee. It's identical leadership team as DAGA. Okay, they're all the same people. Additionally, DAGA pays the salaries of these employees. They're all getting paid from the same bank account. And the DAGA is a committee of the Democrat Party. Okay, it's all coming from the top. Now, this DAGA organization only paid Chris Mays her legal fund after she signed a contract. They did not make any payments to her before the election. They only donated 25 G's to the entire Democrat Party. But then Chris Mays won. It ended her campaign. She got no payments from them at all. Then she took office January 23. Through her chief of staff, she entered into an agreement with States United to provide legal services in a criminal prosecution. Then they came. They delivered a roadmap to Miss Bob and her co-defendants. I'm sure they did the same thing with Fannie. The first payment was made on September 5th. Then a grand jury investigation was initiated. No kidding. Money comes in September. She impanels a grand jury December. Then the office violated Miss Bob and the co-defendants' due process rights. They got a widely publicized, unconstitutional indictment. And then they humiliated her. They wanted to sway the voters in the upcoming election. They said the Trump Republicans are trying to steal your democracy. Then after it happened, boom, second payment, 150 G's came in. Isn't that nice? So this conduct raises serious concerns that Chris Mays has given authority to an initiative, a Democrat group, in exchange for $200,000 to prosecute Republican opponents of the Democrat Party. All coming out from Christina Bobb. Shout out to her for revealing that to us. And here is what she said when she was on Newsmax. You can see why they wanted to take her out, because she can see through the matrix, and she's being asked about what happened with the J6 pipe bomber, the alleged pipe bomber that nobody wants to talk about, apparently, from our government. Still waiting for Cash to say something, or the Capitol Hill Police to say something, or the CIA to say something, or the DOJ to say something, or anybody. But nobody wants to talk about it. And even former Capitol Hill Chief of Police Stephen Sund has said, the silence is deafening, but not from Christina Bobb. Here's what she said about the whole thing.
Christina Bobb is an attorney at Judicial Watch. She joins us tonight. Hey, Christina, how you doing?
Hey, thanks for having me.
Absolutely. Is John Brennan about to get arrested?
It certainly appears that way. I mean, at the very least, the subpoenas are quite intimidating. I suspect we'll see whether or not he actually responds to the subpoena substantively or invokes his Fifth Amendment rights, which is what I expect him to do, and along with the others that are getting subpoenaed. But I'm curious, some of the reporting that has come out is talking about lying under oath or lying to Congress or these types of charges. I am hoping that there are more substantive charges that come out actually relating specifically to their involvement in this Russia hoax, because it'd be nice to actually have people held accountable for the substance of what they drugged this nation through for several years.
That would be nice.
Christina, I think this is pretty simple, especially for the voters and those who put President Trump back into office, and that is anyone who played a role in this needs to be investigated, and if an indictment's appropriate, that's what happens.
That's right, man.
Yeah, I think that's right. And like I said, I think people want to see them held accountable for what they actually did. For example, with Comey, and he's indicted for lying to Congress and, faces potential obstruction of Congress charges. That's great to see people held accountable, but people are angry about the substance of what they did. They're angry that they drugged the nation through a bunch of garbage for several years. They forced down our throats that Donald Trump was a Russian agent or he was somehow aided by Putin, and he's, all of these kinds of crazy things, and we had to endure it. I believe many conservatives want to see people held accountable for what they actually did.
Yeah, I do.
Yes,
they tried to take out the sitting president of the United States. It's nearly tore the country apart here. And then what it means for the country moving forward, it really kind of would mean we don't have one if stuff like this is allowed to go forward here. I want to switch gears, though. Talk about J6, the D.C. pipe bomber. This is kind of interesting. The manhunt still ongoing. Here's some of the video, which leads many to believe, actually, Christina, was an inside job. Now, The Blaze, their investigative reporter, Steve Baker, he's writing that there is a high degree of certainty that the January 6th pipe bomber has now been identified, adding the government's investigation into the J6 pipe bombs was going nowhere. But then just 2 weeks ago, today, that has all changed. And while nothing is 100% certain and everyone is innocent until proven guilty, gate recognition software identified a 94% match. Video proximity tracking and human analysis by federal intel sources. It actually takes it up to what we are told, Christina, is 96 to 98% certainty. And also, Baker says that the highest level sources went on to tell him that that's a woman in that video, she is one of us, and confirmed the reporting that the pipe bomber, in fact, was a female on the inside somehow. You hearing anything about this? Can you talk about it?
Yeah, no, Steve Baker is fantastic. I mean, he has been at the forefront of the January 6th investigation, and he has been breaking story after story after story for years, really since January 6th. That's ultimately why they indicted him, because it was the only way they thought they'd be able to shut him up on his reporting. So Steve Baker does phenomenal reporting. It's no surprise to me that this is potentially likely an inside job. I mean, the fact that they couldn't figure it out for the entire duration of the Biden administration, and then we have the Trump administration, and suddenly it's like, oh yeah, look at that. We figured it out with 99% certainty that we know who it is, and it's one of us. You know, I mean, at this point, it's an embarrassment to the FBI. It's an embarrassment to the Department of Justice. They need to just come clean, release it, admit that know, they had agents in the crowd that we've seen. It's like pulling teeth getting this information out. And you've got reporters like Steve Baker that are doing their job for them. So I commend him for that. But yeah, I'm not surprised at this at all. And I mean, if the FBI wants to continue to be taken seriously, they need to clean out this corruption.
Yeah, they do.
100%. And they're not answering anything. And the silence is deafening, and it leads people to question what is going on over there. Are they trying to get their story straight, or are they okay with accusations just being lobbed around against an innocent person who is still a government employee? So a little guidance from them, whether we're hot or cold, just let us know. Hot, colder, colder, colder. Come out and let us know. But even the chief of police for the Capitol Police Department, former now, says 3 days and still no statement from the FBI or the DOJ. And Stephen Sun yesterday joined in with Newsmax and was explaining his thoughts on this as the former Capitol Hill chief of police, the guy who was there on scene. This is the guy that they tried to blame for the whole thing when Nancy Pelosi tried to frame him. Obviously, he is now furious about this, rightfully so. And he wrote a great book, I think, Courage Under Fire. I think it's back there somewhere. And it's a great book. So check that one out, too. In it, he explains how the National Guard, they were quick. They were pretty quick on the National Guard when they wanted them to go to their homes, but not to the Capitol. Why was that? Here's the former chief of police.
Again, Rob, thank you very much for having me on.
Sure.
And I am very well aware of Steve Baker's report. I've read it. Steve Baker, Joe Henneman put a lot of work into it. Again, I'm somebody that kind of works from facts, and that's kind of the way I've always been since January 6th, trying to put that out there. I would sure like to hear a statement, an official statement from one of the officials, either at FBI or DOJ. And I can tell you right now, nobody knows the impact that had on my safety and security on January 6th more than me. I know the resources I had to send to that. I know the impact it had to our overall security, and no one wants to see the pipe bomber identified more than I do. I'm just surprised that here we are 58 months later, and we still haven't gotten an official, some type of official acknowledgement or a suspect. You know, Kash Patel's been in place over there for 8 of those 58 months.
Yeah.
They've got great technology. They've got great resources and great investigators. I certainly think they'd be able to solve this case.
So you don't
Yeah, if they wanted to, but for some reason they don't want to. Why is that?
want to say whether or not you believe. I mean, we're not going to put her name and her identity on television, but it's out there now. And did you know that woman?
Yeah, I did know the officer, but I think, you know, as the former chief up there, without some supporting facts other than reading one person report, I just don't think it'd be appropriate for me to take one side or another. I'd like to hear more information. I'd like to get more facts. I think the American people want to hear more facts and want to get a definitive answer. Not, you know, it's interesting. Gate analysis has been around. They used it to identify Osama bin Laden. the FBI has that capability. You know, why are we hearing this from a reporter? I want to hear some facts. So, until I can get some facts, I really don't, want to prejudge.
Do you think it's being leaked out from inside? I guess inside the Trump DOJ. Like, how do you think Baker got it? The reporter.
I really don't know. I think from what I understand, he brought in his own resources, his own capabilities to do the analysis. So I'm not getting the impression it got leaked out of the DOJ. But I would think the DOJ has significant information on who we may have as suspects.
Yeah. And why don't they just come out and say, no, we stand by our Capitol Police officers. We've investigated all the various facets of open operations or training exercises. We've done an inventory on all possible devices that might be used in canine whatever. Okay, come up with it. We did a thorough assessment. We stand by the men and women of the Capitol Police Department. We are going to continue to investigate this to find the culprit, because it's not this person. Okay, you get the gist. Just a couple sentences. But they don't want to answer it. And it's not just me screaming about it. It's the guy who was there on scene. Can you just say hot, cold, no, yes, no, please, anything?
I would think so, too.
And again, we are not even accusing this woman, allegedly, of doing anything wrong. Maybe she was an official sanctioned operation and she was just following orders from somebody. And they were going to go. And in hindsight, it's all obvious. Okay. In hindsight, after January 6th, you go, oh, yeah, that was a distraction, a diversion, whatever. You can create criminality and then ascribe it to her. But maybe there wasn't any criminality. What if she was in the middle of a sanctioned training operation and she just said, just go walk around for 40 minutes with these things, where tomorrow morning we're going to bring some sniffing dogs around. They're going to try to track these things down. They're totally inert. Just go drop them off. It's like, is that even a crime? Okay, if it's endorsed by the Capitol Police, are they going to arrest you and prosecute you for that? Of course not. For what, criminal littering, some inert devices somewhere? So she might just be wandering around just like, oh yeah, just sure. Yeah, happy to do it. I'll put the mask on and nobody will find me. I'll seal everything up. Dogs can't know anything. And, we'll walk around. Do it. Totally innocent explanation for it. But she was a government employee, worked there for the Capitol Police. So she was there on the scene. We saw her up on the terrace firing projectiles at people the following day. So she's there. It's very plausible that it's an inside operation in some way, shape, or form because of all of the other facts that we've covered here. And we just have a demand now for answers, and we're allowed to ask our government and government employees what their role was. And if they come out and say it's not her, we'll say, okay, dang, that sucks. Sorry about that. But people get falsely accused of stuff every day in America. Okay, people get arrested and have their blood drawn out of their bodies, and they're innocent. Blood comes back. Oh, sorry about that. No alcohol, no drugs. Why'd you arrest me and take me into custody and then draw my blood out from my body and jab me with needles and things? So again, I'm not saying that we need to attack this woman. I don't want that at all. We just want some answers. She can come out and say, it wasn't me at all. I was here in Florida or whatever, but she's a government employee. Okay. And the left is doxing ICE agents, other federal employees, following to their homes, demanding that they be humiliated and attacked, and the list goes on and on. All we're asking about is what one federal officer did on one particular day, okay? The George Floyd officers are sitting in prison. So we're allowed to hold cops accountable. We're allowed to ask questions about it without being threatened with lawsuits, especially when our FBI has been doing nothing for the last however many years, 5 years now. Coming up. So it's very important that we get answers. And I think, everybody's being cautious about it. And I understand that completely, but I don't want that to chill the demands for answers. This is the best theory that we've gotten. Okay. If the FBI and the DOJ wants us to stop talking about it, give us a better theory. Give us some information. Otherwise, the burden is on you guys. And you put out a $500,000 reward to say, can you help us find it? Yeah, we can. Steve Baker, write him a check. Or give us a denial of it or something.
So we'll leave it there. We don't know, but it's obviously it's a captivating report, I would say. If this turns out to be the case, let's just imagine for a second that this is, in fact, who the bomber was. What does that mean about the truth and the reality of January 6th in your mind?
It was rigged.
So let me say this, rather than answering hypotheticals. I've always said that whoever turns out to be the pipe bomber, regardless of this person or another, is going to put some puzzle pieces into place that I think are going to be critical, because I think this person is going to lead to other people that may be, some of the masterminds behind this whole thing, what happened. Because as the chief, I was faced with depleted.
Look at that ridiculous camera footage. Okay, that was the original one. That's like 1 frame per second. Okay, it's like 3 frames. It's shot in a potato. Look at this person. It's like when our internet breaks here. Nothing is, you can't see anything.
The intelligence wasn't complete. It would have been nice to have complete. Denied resources in advance. Denied resources only up until 5 minutes, not even 5 minutes, 3 minutes before they broke the first one to the Capitol. So there's a lot of questions I've always had, but I think the identifying identity of the pipe bomber is going to be a huge puzzle piece for this.
Do you think, and I don't have much time left, but do you think that is there a scandal here in the people that they can't identify, or the people that didn't get charged in January 6th, people that we know were instigators that weren't charged, the fact that there's no identification of this person when obviously we have the technology to identify them? Do you feel that there's more to this that's being hidden from the American people?
Well, just the fact that we can't get answers gives that impression. So, yeah, I do think there's more answers to get, and I do think there's more to this than we really know right now.
Yeah, there is a lot more to this. And all they'll do is just stay silent. They'll offer a $500,000 reward. Please help us. Please help us. And then when somebody comes out and says, hey, credible people, by the way, Blaze, they've got a whole media team. I'm sure lawyers looking at this. Steve Baker's been on this stuff forever. They come out, hey, we have some information here. Can you please respond to this? Silence. Even the Capitol Hill chief of police is saying, hello, guys, can you help out? So, of course, we're going to keep our eye on this. We're very happy to see whistleblower reports coming out and now answers being demanded on this issue. Thank you for subscribing and joining as we do. All right, my friends. If you're just joining us, quick recap, then we'll hear from you on the day. We saw that President Trump going to the Supreme Court, baby. We're happy to see it. In the case of E. Jean Carroll, this crazy lady, in our opinion, crazy, she now has to respond. And we'll see if the Supreme Court accepts the case. But having read through this motion, this petition, it's very good. Obviously, the trials that we covered here were just a joke. She couldn't remember anything and then pulled it out of her booty. No witnesses, no evidence, no video, and just a bunch of innuendo. But Trump got hit with like $90 million in fines out of New York. Surprise. Now taking it up to the Supreme Court. If he wins on this one, $5 million judgment probably in question, which may translate over into the $90 million judgment. Also going bye-bye. And so a very nice development. We've been waiting for this one, actually. I think I forgot to mention it, but Trump actually asked for an extension on this one until yesterday, November 10th. So it was originally due back in September, but we got the extension and we covered it. All right. So then we talked about James Comey and we read through the transcripts. He had a telephonic hearing yesterday. They're still fighting over this grand jury stuff. He really wants access to it, probably because he's like, oh, dang, they have all that. Yeah, they got it all. So we saw the letter and the motion in response from the Lindsay Halligan DOJ explaining that you're not entitled to grand jury materials. Okay, you're just FBI Director James Comey, former. You're not entitled. No fishing expedition for you, James. And that battle will continue. The judge just got a bunch of stuff under seal, the audio and more. So we'll keep our eye on that, see what happens. And then Christina Bobb in a bombshell report saying that Chris Mays, the Arizona Attorney General, who ended up prosecuting Christina Bobb, inadvertently sent materials to her defense showing that she had a contract with a Norm Eisen nonprofit who was facilitating the prosecution of Republicans. Isn't that convenient? Completely incestuous and disgusting if it's true. And the whistleblower memo now sent over to the DOJ. So maybe they'll look into these people and the investigation will continue. We also saw that Chris Mays may be dropping that prosecution of the election interference and the J6 attack and the alternate electors and all that nonsense made up. She says, yeah, it may have been an inside job, probably is. And the FBI should get its act together if they want people to continue to believe in them at all, and should respond quickly on that. And then Stephen Sun came out, very cautious man, rightfully so, but says we need to hear something. Okay, it's been 3 days. Still no statement from the FBI or the DOJ. Let's see if we got anything from Cash. Veterans Day. Okay, nothing there. Let's take a look if we have anything from Pam and whether she submitted anything. Today, no. Antifa. The violent riots at Berkeley. Yeah, what are they going to do? Under Trump, the Department of Justice are dismantling violent networks. Well, they seem pretty mantled yesterday out at Turning Point. They didn't seem too dismantled, screaming at people, yeah, white boy. Yeah, where's your homie? Your homie's dead. All right, so nice tweet there, Pam. All right, so now, my friends, it is time to hear from you. Let's see what you say about all of this. Thank you for being here. Happy Tuesday. We got new membos coming in too. Membos, stick around. We're going to have an after party in just a few minutes and see what else you have to say about what's going on out there. What a bunch of nice donos, my friends. Thank you for sending these in on the day. It's Trump. It's Taco Trump. It's Trump Taco Tuesday, amigos. Get your taco bowls, baby. That's a real photo. I'm pretty sure that's real. That's Trump was in Trump Tower on Cinco de Mayo. Amazing. It is Taco Tuesday, man. Love a good taco. All right. Hey, Oso Yeti. What's up, Oso Yeti? Welcome aboard. We'll see you in just a few minutes. Colleen Page. What's up, Colleen Page? 9 months as a membo. Hi, all. When does this start? That was about 2:40, about 10 minutes from when you sent that in. Hopefully you're still here. Colleen Page, thanks for being a membo and for being here for a full term of a child. We appreciate that. Bucky's is Rome shared this message. Said, enough. Either Trump becomes the American. We'll have to come back on that one. I can't really read that one, but thank you for that. Bucky's is Rome. Let me see if I can figure that one out. Hey, John McGarvey. Hey, Rob, as I watched you flounder yesterday with our friggin' internet, I realized that I wouldn't want to have thousands of people watching me and fail in such a spectacular way. It's true. It's true. I don't want it to happen that way, but it happens. And fail in such a spectacular way. I mean, just like epic failures. I mean, failures that would humiliate and embarrass anybody else. But what, here we are, we're back. And fail in such a spectacular way. I was passing a kidney stone this last weekend, and I still wouldn't have traded places with you because you're so pathetic and such a loser. And everybody got to see it. Thanks. John's a great friend of our show. He really, we've been around for a long time. We really love John. And he's right. Well, you can't even argue with it. It was an epic and catastrophic failure. And after it, I went outside and walked in the rain for about 4 hours and just contemplated my life. What am I doing? Who am I? What is this all about? What is this for? How can I be such a failure? How is this even possible? But we're back. Here we are. Thanks, John. And K Bean liked that comment too. Isn't that nice? Thank you, K Bean, for liking John's comment. Obliterating and ridiculing us. Love you guys. King of Biltong. Hey, what's up? Get your Biltong. We also specialize in imported foods over there. Check out Biltong USA for a great selection of imported candies, cookies, groceries, and of course, Biltong, baby. It's at BiltongUSA.com. And if you plug in code Robert over there, you're going to save 10% off. What a great deal. What else are you eating? Beef jerky? Pfft, get some Biltong. One old guy. Hey, I wonder if anyone will face charges for a false report. Is that something that can happen? Yeah, I mean, it's certainly a charge. Like false reporting is definitely a charge. In what context? Like a false reporting on the pipe bomb or J6 or FBI. I'm for charging everybody with everything if they're part of this conspiracy. Hey, psychological projectionist, what's up? By propensity evidence, a person who robs one bank is guilty of robbing every bank, including those with no evidence of having been robbed. It's ridiculous. Yeah, it's why we don't allow it in, really. It's not useful evidence. And it can be absolutely perverted, right? So as we saw, they just say, well, Trump said this and he said this. Okay, what does that have to do with this claim right here? Did he grab her purse or not? Well, he said on Access Hollywood that he did grab other women. Okay, well, what about her? Well, it sounds close. So we just don't keep it in. Hey, what's up? One old guy says, dumb as a crat. Say that 3 times fast. Dumb as a crat, dumb as a crat, dumb as a crat. Voting for Harris. Yeah, that sounds good. Hey, that guy. I remember him. Oh, too old, am I? What's going on? One old guy's opinions. Hey, thank you, my brothers and sisters at arms, for serving with me. Shout out to our veterans. Veterans are more important than illegal aliens. That's true. Too many on the streets. Vets homeless while illegals get SNAP and government housing. Screw the illegals. Yeah, man. It's wild. We had no problems in America. In fact, everybody was housed, fed, treated for healthcare. Everybody got all the benefits that they needed. Everything was so good in America. We could also help 20 million more. It really is sick what happened to our veterans. What happens to our veterans, what happens to the people at their expense on behalf of foreigners. It's really gross. One old guy. Be a more involved grassroots voter at the local level. Don't let Sharia law become the law of the land. Also good advice. The Constitution should be the law of the land. Mizzy M. Wasn't able to listen to your show last night. Guess it was the right night to miss it. Yeah, probably was. I mean, the content was good up until the internet stopped working randomly. Everything was fine, humming along, and then you're done. Yeah, so you missed it. Nikki P. Hey, taking number 4 grandbaby early 2026. Prayers high risk. Okay, prayers up for Nikki P and the Nikki P household. First of all, Nikki P. Yes. So are you saying from now? Okay, so maybe a real grandbaby's coming November 26th. High risk pregnancy. That's amazing. And you've been here for multiple babies as well. So thank you, Nikki P. We appreciate that. Prayers up for the mama who's having the baby, and your grandbaby will arrive perfectly. What's up, John McGarvey? Oh yeah, Eric's House. ericshouse.org has an auction. John McGarvey is sharing that with us. Of course, ericshouse.org, a nonprofit organization that your boy is affiliated with. My mama started it, and it is for people who've lost somebody to suicide, overdose, or other tragic death. It's a grief support nonprofit and organization. Oftentimes what you'll find is that there's a lot of services for people who are sick and unwell. Like if you're an addict, they'll put you in rehab. But if you die, then there's not much else that you can do, right? The family's kind of like, all right, good luck, see ya. So Eric's House, after my bro died, Eric, is now committed to helping people through that process. So if it's relevant to you, check it out, ericshouse.org. And they've got their annual auction and fundraiser going on right now. Zena, thank you, John, for plugging that. What's up? Zena Xavier. Hey, thank you for your service to all veterans. Shout out, Zena. Thank you for saying that. Thanks for being here 32 months and shouting out our vets. We love our vets. Rubos. Oh, it's Rubo time, baby. Did you get your salt yet from the Rubos? They still have a live promo here, courtesy of our wedding. 35% off a two-pack of premium Rubo salt. RuboSaltShop.com. Here's an idea. Dry brine your turkey with our hand-harvested French sea salt from the oceans of France. 9 organic herbs. The secret to juicy, unforgettable flavor. Just lavish that thing up. Pure traditional, crafted with love. Go to RuboSaltShop.com. WTW35 at checkout will save you 35%. Shout out to the Rubos for honoring our wedding. Amazing people. Hey, that guy. Man, I love those movies. Grumpy Old Men. Those were great movies. Hey, one old guy's opinions. Watching all of Comey's defense team motions and legal moves makes me wonder how this Comey idiot ever rose to these high places in his career. Well, fraud, lying, and corruption goes a long way. Rubbing everybody's back. Guess the old saying is, it's not who you know, but who... one old guy. Can't read that one. Rick Donner. What's up, Rick D? Ruh-roh, Tish. Police called 24 times to Letitia James's family homes. Oh, that's just amazing. That's amazing. She's the attorney general. And there's probably multiple domestic violence offenses, drug crimes. Who knows what's going on over there? That's amazing, Rick D. Thank you. Dark Rogue. Hey, by any chance, is the intern who accidentally released that info of Maze's payments, are they a missing person based on a previous history a la Whitewater? It's a good question, Dark Rogue. If they're not, they're probably on high alert. They're probably every time Chris Maze calls them, they're like, oh gosh, this is it. They're coming for me. One old guy, good to see you, says, Democrats sound more and more like any other political party in history with authoritarian, totalitarian aspirations like the communists and the fascists. No wonder Sharia law people gravitate towards the Democrat Party. Yeah, that's an interesting comment. Yeah, I mean, I think that there's maybe a similarity between all of those, right? It's kind of top-down law, and everybody has to participate or else you're excluded. right? And in some cases killed. So yeah, thank you, one old guy. We like our Constitution and America, and we don't want the people here perverting it. Bruce Wayne, what's up? 21 months as a membo. Good to see you, Bruce Wayne. Indictments incoming. We can hope. Yeah, we can hope. A lot of criminals out there who need to be held accountable. They deserve all due process, presumption of innocence, all of that. But no one is above the law, Bruce, as we know. 200 Watt Studio says suddenly Pam Bondi is nowhere to be found. In the beginning, she was on cable news every day. Now she's posting tweets about Antifa as they're attacking Turning Point events. Man, if the Democrats were in charge and that was happening, they would have facially ID'd every one of those people. Anybody who threw a rock or anybody who I mean, the J6ers, if you threw a water bottle, okay, you were getting arrested. Why are they not doing that to these people? Because they're weak. That's why. 200 Watt Studio, nice to see you. Hey, Off-Label Podcast. The innocent explanation doesn't hold water when you think of how much they knew about J6 beforehand. Why train on such a busy day? That's a good question. But she may not have been privy to that, is my point. Like, if it's all compartmentalized, like, really, on J6? Like, yeah, just go drop these things. Okay. Maybe she's done it 5 times before. You know, so another one? Okay, where do you want them? Yeah, put them over here, put them over here. All I'm saying is we're not accusing her of any wrongdoing or trying to, attack her credibility or anything. We want some answers. Is it, what was that you? If not, just say no. Oh, if it was you, what were you doing? Oh, it was an official training operation? Well, who approved that? Follow that bouncing ball up the chain. Good to see you, Off-Label Podcast. Make sure you subscribe to them right next door. One old guy's opinions says saying nothing is plausible deniability, but not saying anything can also mean an admittance in some cases. No? Yeah, but like they have to respond. If this is a government employee, they asked for information. They asked for $500,000. Okay? Give us info. 500 G's coming to you. Public comes out. We've got an answer. All of a sudden, don't want to talk about it. Come on, guys. It's your employee. This person still works for the government, allegedly the CIA. Aren't you going to come out and defend your employee and your agencies? No. Why are they not speaking? Hey, Dark Rogue. What's up, Dark Rogue? Bringing in 10 membos. Thank you, Dark Rogue. Look who's coming in. Fred Prevo. We got BB now is here. What's up, Jane Doe? MNEF. We got Just Me. Brenton Beck. Captain Spaulding. Jennifer in the house. We got some others, including Woodgetter, Slough Rider, Joe D.C., and others, all coming in, courtesy of our friend, Dark Rogue. Thank you, Dark Rogue. Welcome, new membos. Great to have you. MM is bringing in 2 souls for you. Cherie, Marty Smith Fansu, welcome. Tom Minier and Aldous Orwell, all gifted membos, courtesy of MM. Welcome, friends. One old guy also says, in the case of an organization or organizations all silent at the same time, that would be admittance of, yes, we did it, especially given the government's inability to speak the truth ever. Yeah, and if they're not going to give us information and incentivize us to gather information, then that's what they're going to get. And this person works for it's like a private innocent person who's like, maybe she is, but the agencies should be defending her, and they're not. What's going on? More here. Bringing in 10 more here. What's up, Rudy, John, G, Helix, Level? We got many others coming in. Welcome aboard, courtesy of our friend, More here. And Elena, a.k.a. Neely, also bringing in some membos. Amazing, Elena. Thank you for doing that. Also says, congrats on your marriage. I love your wife as Christ loved his church. It's in the Bible. Submission is easy in that kind of love. It's in the Bible. Alexis read me that phrase, that passage from the Bible, I think the day before our wedding. Thank you, Elena. She's amazing. Hey, Pete Smith. Got my Rubos order today, baby. Can't wait to try it out. All my new salts. Good for you, Pete. You're going to love it. I don't know what you were using before, but you can toss it. This is much better. And you're going to be sophisticated because you're eating salt from the ocean of France. That's how I feel every day. It's beautiful. Off-Label Podcast. Haha, your crew is awesome. Cheers to them too. So you too, Off-Label, huh? You're on Team John and K. Bean, huh? in my humiliation. So I deserve it. Sheila Poo, what's up? Welcome. Sheila, bringing in 10 membos. Thank you for doing this, Sheila. We got Jake Jameson, Lillian Murray, Foxy Dog, Itchy Paws. Welcome. Petco has an Adopt a Fur Kid Day. That's fun. Daniel Jockers, what's up? Swamp, Scott, Mr. JP Tiger. We got Judith, Hall Barrett, Leslie Stewart, all gifted membos in the house. And great to have you. Hey, don't worry yourself about yesterday, Robert. You're not directing air traffic. Yeah, it's a good thing I'm not, too, isn't it? Come on in. This live stream is live right now. And everybody dies. Plane crashes, huge fireball. We're all dead. It's a good thing. But thank you, ELZ. That makes me feel better. Nobody fell out of the sky when the stream didn't work yesterday. Probably. That's good. Hopefully we didn't kill anybody. Okay, Sheila Poo. Hey, what's up, Sheila? Now that you start at 4 my time, I'm late. So it's 4. So it used to be 5. Yeah, it's Arizona. We don't move. We don't change times. Good to see you, Sheila. Thanks for being here for 21 months as a membo. One old guy says, I'm a Texas-born Mexican, American, who took Spanish at night school and got a B. Cheech and Chong reference for the young people. It is Barbecue Rib Tuesday for me. Yeah, there was a time when we were not doing Taco Tuesday because of all the illegals. But tacos are good. And we can appropriate their food if we want to. Scott Ross, what's up? Spaghetti. Ooh, also good. Love me some good spaghetti and meatballs. Mama makes some good meatballs. We did a whole meatball stream. And Alexis makes them now too. She's got the recipe and she's like a connoisseur. And they're delicious. So good to see you. Yeah, it's called American, okay? Not Americant. Okay, so we're going to get it done. Albert the Marine, what's up? Shout out to our Marines. Had a birthday yesterday, and happy Veterans Day. Keep up the great work. From an old retired member of the only service born in a bar, 250 years old, and we still don't need a walker. Amazing. Shout out to our Marines. We were celebrating you yesterday, and the Army folk were talking all sorts of garbage, man. I'm like, what's going on over here today? Good to see you. Thank you, sir, for your service. Appreciate you being here. Chetty Mo, what's going on? 18 months as a membo, says 2 babies. Boom. Love the show. And hi, chat. What's up, chat? From Chetty Mo. Good to see you, Chetty. Thanks for being here. 2 full babies. Look, there's a baby right there. Good to see you, Chetty. Thanks for being here. Rick D. Okay, breaking. SCOTUS extends the stay on the SNAP benefits for now. Blue states lose again. I saw, so we may have covered that today, but I kind of feel like it's going to be moot in a week. Once the government reopens, I think all the fighting over SNAP is just going to be moot. So Supreme Court blew them out again. Trump doesn't have to pay all the benefits right now because there's no money. McConnell said, steal from these kids to feed these kids and all of the other people too. Yeah, Bucky's is Rome. Police were called to homes at the center of Letitia James's fraud case 24 times. That's just great. We'll probably talk about that tomorrow. Psychological projectionist. Pipe bomber. The case of the dog that didn't bark. Yeah, and they're all so quiet about it. We're going to find this pipe bomber. And where's also the gallows guy? Where's that guy? Any update on that at all? No. He's missing too. Who built the gallows? FBI can't figure it out. That dude's face is like half uncovered. Off-label podcast. I mess up on producing all the time, Rob. Yeah, man. You know, live streaming. It's an adventure sometimes. Usually it's just fine. Technology just works flawlessly for us, but other times they make me want to throw the entire device right out the window. And I'm often very close to doing it, but we don't. We have some self-control here. So let's see who else is joining us on X, my friends. And then we're going to wrap it up on the day. Going to have our members only after party time. We'd love to see you if you became a membo. That would just be beautiful. Guernica. Yeah, I know. And then Cash, when the story was breaking, Cash Patel was in China. What's he doing over there? Kyle Serafin's been all over it. What's up, Guernica? Yeah. And also Kyle, right? He was pulled from the location. So it's not only gate analysis that is the problem. It's also, we've got corroborating investigations that are being perverted right around the same time. Hey, Hellfire Tactical. What's up, Hellfire? Happy Veterans Day. Shout out to Steve Baker also getting tagged over there. And Neuro D. Think about following us on Rumble. if you want to join us over there. This is our X account, my friends, if you care to follow us over there. And it's been a beautiful day and just an amazing stream. Happy Tuesday. We're going to pause here for the night. Go over, hang out with our members for just a few minutes. Of course, we'll be back tomorrow with our member stream in the morning. If you care to join us, thank you for becoming a member. We're appreciative of those who sign up, and we'll see you in just a minute. But we'll pause here for the day. It has been a beautiful stream. Thank you for joining us. Thank you for subscribing to our channel if you haven't already done that. Thanks for liking this video and inviting everybody you've ever met in your entire life to come join us tomorrow when we go live, because we're going to be back to do it again. We also want to thank our amazing mods and meme smiths. Big thank you and shout outs to Donut Mind Me, to John, who is just incredible. We love you, John. Glad you enjoyed the show yesterday. And to our friend Muffin Rando. We also have Neuro D. Thank you, Janek, Dog Digger in the house, Elliot, G-Gum, Just Rhonda, K-Bean, and Carrie B. modding the fort down for us, keeping things nice and beautiful and orderly around here. But my friends, oh, look at this little puppy over here. You see that tail? You want to come say hi? Where are you at? See that little face? Oh, here it is. Pop up. Oh, say hello. There he is. This is Axel. Come over here. He gets camera shy. Come over here. Come over here. Come over here. All right. All right. All right. So he gets, normally he'll pop right up, but he gets a little camera shy. You know, that happens to people. All right. So my friends, we'll leave it there on the day. Thank you once again for joining us. Thank you for subscribing to our channel. I want to wish you the most beautiful rest you've ever had. We're coming back tomorrow to get into it again. And in order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. We'll see you right back here tomorrow. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through